Then we'll get on to case study 3, which is not so much involved. There we'll look at the private trust company, look at the liability exposure of a private trust company, and then look carefully at whether or not a director can be made to be liable to beneficiaries of a trust for incorrect or sort of maladministration of the PTC's underlying investment funds. This is just a private trust company scenario, so this is quite obviously very, very popular nowadays. Private trust companies, the issue around them is they are obviously not of substance. They're not a licensed entity. They don't have all of the sort of resources that you would expect from a licensed professional outfit. And that leads on to some issues surrounding the ability to enforce any judgments on a breach of trust against a private trust company. So we say in the round, the private trust company is pretty judgment proof. One question though that comes up is this: what can we do against the directors of the private trust company? Can we sue a director of a private trust company for the maladministration of the trust fund? In other words, this is the sort of name that they use, it's a dogleg claim. Is it possible within Singapore context to sue the director of a Singapore private trust company for the economic losses suffered by the trust because of the effective negligent administration of the fund? Insofar as UK authority, no, you can't do it from a UK perspective, but from a Singapore perspective, can we sue a PTC director for losses to the trust fund? And I'd ask Victor to kick us off.
Sure. This position, to my knowledge, hasn't actually been decided in Singapore. I think even in the Commonwealth, it's, there have been a few cases that talk about dog-leg claims, right? Where essentially the position in the UK is that you can't sue a director of a trust company for breach of its duties to the beneficiaries, right? There's a break in the link. But how some clever lawyers try to get around this is to say that it's not that the directors were breaching his duties to the beneficiaries, he was breaching his duties to the company, right? The PTC itself. But there have been very, scarce cases and nothing in Singapore. So I think it's a bit of a stretch to go there.
Yeah, and do we all agree, Winham and Lin Chuan, do you agree that to successfully get a dogleg claim against the director on a PTC in Singapore is probably not likely to happen?
Yeah, I think that's not likely to happen, and some statutory provisions are written on the assumption that there may be no such claim. So in the Business Trust Act, for example, where statutory duty was imposed.
Right.
Yeah. So I agree. There are no cases in Singapore as far as we're aware. But if you read dogleg claim and how it works, right, it's actually a 2-step or 3-step process. So it's indirect. So otherwise, the default position is separate legal entity. If the trustee causes a loss to the beneficiary because of a breach of trust, you go after the trust company first. Then what happens is where the technicality of the dogleg claim comes in, where you can have the second step, third step, indirectly to take over the claims or the asset rights of the trustee company to go after the director. So it's quite difficult.
Yeah. Okay. I suppose then the remedy, I guess, if a private trust company board of directors fall out with beneficiaries, is a trustee removal. And the interesting thing here, and obviously you have Section 42(1) Trustee Act here that's pretty much modeled on all of the trustee acts around the world that allow the court to exercise its discretion to remove a trustee. But the interesting thing, looking at some of the case law on this, which is quite ancient, is that it doesn't have to be on the basis that the trustee actually committed any level of breach. It's just that there's a fundamental falling out between the trustee and the underlying beneficiaries, which the court would encourage the trustee to effectively retire in those circumstances. I just wonder, within a Singapore context, undoubtedly the Singapore court would take the same view, that if there's a radical falling out between the beneficiaries and a trustee, albeit a PTC, the PTC ought to retire as trustee, or I guess the directors ought to shuffle. I mean, does anyone have a view on how Singapore courts would interpret the falling out between the parties, which would lead to a trustee sort of retiring or being removed? I think, Victor, if you could give us a few words on this?
Yeah, I think that the general common law position is that if you can get a removal if it's considered detrimental to the trust, right? And there has been the Medwell case as well, where there's such a degree of hostility between the trustee and the beneficiary, which has resulted in an incurable breakdown in communication. So I think that's probably the position that will be followed here as well.
Mm-hmm. Okay, and does everyone else agree or have anything else to say on this? Anyone else agree? Okay, all right, I think